Supreme Court chamber in the extraordinary chambers in the courts of Cambodia, and I'd like now to read the internal regulations of the Supreme Court chamber. The internal regulations aims to govern the courtroom on public hearing day. In order to ensure the public order, security, and the effective functioning of the courtroom during the public hearing day, the President of the Supreme Court Chamber has established the following internal regulations regarding the appeal hearings in case 002/01 as follows. 1. All persons who wish to attend the hearing shall be present in the courtroom, the extraordinary chambers in the courts of Cambodia, by 8:30 a.m. in the morning and 1:30 p.m. in the afternoon. 2. Participants and persons in the public gallery, except the monks, shall stand when the greffier announces stand and sit when the President of the Supreme Court Chamber announces sit down. 3. Participants shall maintain dignified and proper behavior in the courtroom at all times. Participants shall wear appropriate clothing. Their clothing may not display slogans, indicate their support for a party of the proceedings, or be otherwise offensive in any way. Banners and posters will not be permitted in the courtroom. 4. All cameras, camcorders, tape recorders, and loudspeakers are prohibited in the courtroom, except as approved by the President of the Supreme Court Chamber. 5. Smoking or bringing food or drinks inside the courtroom is prohibited. 6. All weapons, explosives, ammunition, and inflammable substances are prohibited inside the courtroom, except for those carried by the ECCC's authorized security guards. 7. The use of cell phones is strictly prohibited. Phone cameras and phone audio recordings are also prohibited, except as approved by the President of the Supreme Court Chamber. 8. All persons are prohibited from changing seats or walking freely inside the courtroom. 9. All persons are prohibited from clapping, cheering, shouting, or making loud noises that might disrupt the hearing. 10. Permission must be granted by an ECCC authorized security guard in order to enter or exit the courtroom. 11. Children under 16 years of age are prohibited from entering the courtroom. Persons between 16 and 18 years of age may enter the courtroom if they are accompanied by a parent or legal guardian, unless they are attending the public hearing as civil parties or witnesses. 12. Pursuant to the internal rules of the ECCC and the applicable laws of the Kingdom of Cambodia, the President of the Supreme Court Chamber may take preventative measures or direct action against any person who breaches these internal regulations made in Phnom Penh, 13 November 2015, President of the Supreme Court Chamber, Cung Srin. Thank you.
Veuillez vous lever.
Please be seated.
Président, veuillez vous asseoir.
President, in the name of the United Nations and the name of the Cambodian people, the Supreme Court chamber in the extraordinary chambers in the courts of Cambodia opens its hearing to hear the appeal against the judgment dated 7 August 2014 of the trial chamber of the ECCC in case file 002/19 September 2007 with the co-accused Nuon Chea and Keo Sampon. The bench is composed of the following judges: I, Kong Srim, the President, Judge Chandra Nihal Jasinghe, Judge Sam Sarivut, Judge Noviska Milad, Judge Mongmani Charya, Judge Florence Nepet Mumba, and Judge Ja Naren. The greffiers are the following: Mr. Walker Malich, Mr. Siemau, Mr. Sila Pailan, Mr. Paulo Lomba, and Mr. Pontoon. And Mr. Siemau, are the parties all present?
Siemau, veuillez faire état des parties présentes à l'audience ce jour. Sont-elles toutes là?
Greffier. Mr. President, the parties to this case are present, except the International Council for Nuon Chea, that is, Council with the Copper is absent. Thank you. National Council for the Defense of Nuon Chea, could you inform the Chamber the reason for the absence of your International Council for Nuon Chea?
De l'absence du Conseil international de Nuon Chea.
Sonaran. Good morning, Mr. President. Good morning, Your
Monsieur le
Honors.
Président. Madame, Messieurs les juges, bonjour.
My client, Mr. Nuon Chea,
Mon client, Nuon Chea,
would like to seek your permission to make a statement which lasts for about 20 minutes.
Une déclaration qui va durer à peu près une vingtaine de minutes.
His statement will indicate the reasons for the absence of his International Council for the Defense.
À l'origine de l'absence du Conseil international de sa défense.
President, the International Co-Prosecutor, please be seated. Allow me to follow with our scheduling.
De suivre le programme qui a été établi.
The National Council for Nuon Chea, is it your statement that the absence of the International Council is per instruction of his client, that is the accuser Nuon Chea? Am I correct? If there is a case, we still follow with the proceedings for the appeal hearing.
Continuer de suivre le programme des audiences en appel.
Per procedures, that is pursuant to Internal Rule 22.1 of the ECCC Internal Rule. Despite the absence of the International Council, the National Council for the Defense cannot proceed to defend your client. Yes, I can follow the proceedings.
Oui, mais c'est le cas.
President, thank you, Counsel. You may be seated.
Président, merci. Veuillez vous asseoir.
The Chamber would like to inform the parties that I will first start the opening of the appeal proceedings.
Les procédures en appel.
And I noticed that the International Co-Prosecutor wants to take a stand. Before I proceed with the opening, you may take the floor.
Good morning, Mr. President, Your Honors. What I was going to suggest is the question, Mr. President, that you asked. I think it's important to clarify that the absence of the International Co-Counsel for Nuon Chea is with his consent. I'm not sure that the record is clear from what was translated about that. All I heard on the record was Mr. Sonomoon say that he could follow the proceedings. But if, please, I hope Defense Counsel, National Counsel will correct me if I'm wrong, but are we correct then in all of us taking his answer to mean that Nuon Chea consents to the absence of his international co-counsel?
De son conseil international.
President, regarding this matter, and as stated by the National Defense Council for Nuon Chea, the accused Nuon Chea himself will make a statement.
Nuon Chea lui-même va prononcer une déclaration.
And for that, the Chamber will give the floor to Nuon Chea to make his statement after my opening a statement of the appeal proceedings.
J'aurais prononcé mon allocution d'ouverture des appels en audience.
Today is the first day of the appeal hearing of the appeals brought by Nuon Chea and Khieu Samphan against the judgment of the trial chamber of 7 August 2014 and the co-prosecutor's appeal regarding the applicability of the notion of joint criminal enterprise in its extended form. The Chamber has received extensive written submissions in which the parties have set out their arguments in support of their respective appeals and the responses thereto. The Chamber has carefully studied and analyzed all these submissions in preparation for this hearing. It is not the purpose of the appeal hearing simply to rehearse the written submissions. Rather, it is an opportunity for the parties to highlight the most important aspects of the appeal and, in particular, to reply to arguments contained in the responses to the appeal briefs. Furthermore, I recall that in July of this year, the Chamber held a hearing to hear 3 additional witnesses on appeal. Moreover, the Chamber admitted 8 additional documents into evidence. The appeal hearing that commences today is an opportunity for the parties to make submissions in relation to the additional evidence admitted on appeal by this Chamber, including the testimony of those 3 witnesses. It must be underlined that, as reflected in Internal Rule 1096, the appeal hearing is not a mechanism for parties to raise matters of fact or law that were not previously set out in their submissions on appeal. I would like to invite the parties to keep this in mind when making submissions before the Chamber. The appeal hearing also provides the judges of the Chamber with an opportunity to ask parties for clarification of their submissions and to address questions that, in the view of the Chamber, are conducive to the determination of the appeal. Some of the questions were communicated to the parties on 5th November, together with the final timetable for the appeal hearing. Nevertheless, the judges of the Chamber may ask additional questions throughout the appeal hearing. In each session, there is time reserved for questions by the Chamber. The judges may also ask questions at any time in response to the submissions of the parties. In order to ensure an efficient use of time, the Chamber has decided to split up the appeal hearing into 6 thematic sessions, grouping the various grounds of appeal. The first 5 sessions concern the appeals brought by Nuji and Keo Sampon. The appellants have submitted several hundred arguments in support of their respective appeals, alleging factual, legal, and procedural errors. The Chamber has attempted to group them to make it easier for the public to follow the appeal hearing. In an annex to the initial scheduling order for the appeal hearing, the Chamber indicated which grounds of appeal and paragraphs from the appeal briefs should be discussed in the respective sessions. I should highlight that sometimes this categorization was not easy to make, and some grounds of appeal could fall into more than one of the sessions. The first session, which is to start immediately after this introduction, concerns the grounds of appeal, alleging violations of the accused's fair trial rights, as well as the issue of whether the ECCC's internal rules are unconstitutional and illegal. The second session concerns the grounds of appeal related to the trial chamber's overall approach to the evidence. This session is scheduled to commence the day after lunch. At the end of the day, time is reserved for the Supreme Court Chamber's questions on the subjects covered during today's sessions. Tomorrow morning we will start with a session dedicated to the grounds of appeal related to the crimes for which the accused were convicted. After lunch, the Chamber will commence with the session on the grounds of appeal related to Nuon Chia's and Khieu Samporn's individual criminal responsibility. We shall conclude this session in the morning of day 3 of the hearing. Also on Thursday morning, the Chamber shall hear submissions in relation to Khieu Samporn's arguments on appeal regarding the sentence imposed by the trial chamber. Thursday afternoon is dedicated to the appeal of the co-prosecutors, and there is time allotted for final questions by the Chamber. During this last part of the hearing, the accused may also address the Chamber in person, if they so wish, in accordance with Internal Rule 109.5. As to the conduct of the individual sessions, in compliance with the applicable procedural rules, notably Internal Rules 108.5 and 109.4, each session will start with a report of the co-rapporteurs. I appointed the co-rapporteurs for the appeals of Nuon Chia, Khieu Samporn, and the co-prosecutors in June of this year to address each aspect of the appeals. Given the size of the appeals and the large number of grounds of appeal, the co-rapporteurs' reports do not attempt to summarize comprehensively and in detail all the submissions on appeal. Rather, they serve as an introduction to the relevant session and as an overview to the general public of the issues raised on appeal. If a particular argument or ground of appeal is not mentioned in the report, this does not mean that the co-rapporteurs have overlooked it. Following the co-rapporteurs' remarks, the parties will be invited to make their submissions in the order indicated on the timetable. The parties are instructed not to go beyond the time allotted to them, as we are running on a tight schedule. Should it appear that particular aspects of the submissions require more time, the Chamber has discretion to afford the parties additional opportunities to supplement their submissions in the time reserved for the judge's questions. This will not be done routinely, but only if strictly required. Finally, in keeping with Internal Rule 109.4, I would like to inform Nuon Chia and Khieu Samporn of their fundamental rights under Internal Rule 21D. This provision reads as follows: every person suspected or prosecuted shall be presumed innocent as long as his or her guilt has not been established. Any such person has the right to be informed of any charges brought against him or her, to be defended by a lawyer of his or her choice, and at every stage of the proceedings shall be informed of his or her right to remain silent.
The
judges at the bench discuss the proceedings, and we decide that the appeal proceedings will proceed despite the absence of the International Council for the
du
accused,
Conseil
Nuon
international
Chea,
de l'accusé.
and the decision will be
audiences
made
vont
later
se
regarding
poursuivre.
his absence.
La décision concernant
And
son
I would
absence
like now
sera
to
prise
give the
plus
floor
tard. Et je
to
souhaite à présent
Nuon Chea
donner la
to
parole à Nuon Chea
make his statement,
afin qu'il prononce
and the
sa
time
déclaration.
allocation to you is not more than 10 minutes, and you
Vous
may
n'avez que
proceed.
10 minutes. Vous avez la parole.
សូមមន្ត្រីពន្ធនាគារសូមអញ្ជើញនាំជនជាប់ចោទមកនៅ
Security personnel, please escort the accused into the dock.
Agent de sécurité, veuillez amener l'accusé à la
សូមគោរពលោកប្រធាន
Kong Sam On,
l'avocat national de la défense de Nuon Chea.
អល់ថា
Brother Sonaron, Mr. President, I'd like
Monsieur
to
le Président,
seek your permission
J'aimerais vous demander la
that the
permission
statement to be read by my
pour
client,
que
Nuon
ces
Chea,
commentaires à cette
may
déclaration
take
qui
longer
doit
than
être
the
lue par
allotted
Nuon Chea
time, as this is
Nuon
a combined statement,
dispose de plus de temps puisqu'il s'agit
also covering
de
the aspects
commentaires
of the
combinés qui couvrent
International
plusieurs
Council
aspects,
for his
notamment
defense, and it may
l'absence
run into
du
20
Conseil
minutes.
international.
And we
Donc,
seek
ça
your
risque
permission for
de
that.
dépasser les 10 minutes que vous venez de nous allouer, atteignant probablement plutôt 20 minutes. C'est pourquoi nous aimerions votre autorisation pour avoir ce temps de parole.
Ờ, ខ្ញុំសូមជំរាប ទៅ
President,
លោកមេធាវីរួមទាំងជនជាប់
the
ចោទ
Chamber
នួន
would
ជា
like
ផង
to
ដែរថា
inform the Defense Counsel for
Président,
Nuon Chea, as
la
well as
Chambre
Nuon Chea himself,
informe le Conseil national de Nuon Chea ainsi que Nuon Chea
that the statement to be read by the accused
Que la
is
déclaration
just part of the
lue
introduction of the
par
appeal proceeding,
Nuon Chea fait
and as
partie,
indicated
se fait
by
dans le
the
cadre
National
de
Defense
l'introduction
Councel for
aux
Nuon
audiences en
Chea,
appel, et comme ça a été indiqué par l'avocat
he will
national de Nuon Chea,
participate
il va
in the
participer
proceedings of
Ce
this
dernier,
appeal
l'avocat
hearing.
va
For that
participer
reason, please try
aux
to make
audiences
the
en
statement
appel.
as short as possible
C'est
per
pourquoi
allotted time.
Vous êtes prié de faire au plus
Nuon Chea.
bref possible.
My respects
le
to
temps
my
imparti.
beloved
Nuon
fellow
Chea.
Cambodians and to all those
Mes respects
genuinely
aux
committed to
vénérables
truth and justice. I am
compatriotes
Nuon
cambodgiens
Chea,
et
and I
tous ceux
was the
réellement
former Deputy
engagés vers la
Secretary of the
recherche de la
Communist
vérité. Je
Party
suis
of
Nuon Chea,
Cambodia.
j'étais l'ancien secrétaire
8
adjoint du
years
Parti
and 2 months
communiste du
ago,
Cambodge. Il y a
I was
8
arrested
ans et 2
and
mois,
brought
j'ai
before
été
this tribunal.
arrêté et déféré devant
I
ce
have been
tribunal.
engaged in proceedings
J'ai
here
participé
ever since.
à la procédure
I thought
depuis
that
cette
this
date.
process,
Je pensais que ce
if
procès,
done right,
s'il était bien mené,
could allow Cambodia,
pourrait
as
permettre
an
au
innocent,
Cambodge,
justice-loving
en
nation,
tant que nation innocente
to
et
come
éprise de
together
justice,
and
de se
meaningfully
réunir et
discuss
d'échanger
what
constructivement
happened
à propos
during
de ce
the
qui s'est passé
democratic
pendant la période du
Cambodia
Cambodgia
period.
démocratique.
It could be our chance, our only
Parce que cela
chance,
pourrait
to
être
learn the
notre
truth
chance, notre
from
seule
me
chance de connaître la
and
vérité
from
de
all
ma
those
bouche
who lived
et de
through
celle
the
de tous
period
ceux qui ont vécu pendant cette période.
before we die,
Avant que nous
and
mourions
take our memories and
et
experiences
emportions nos
to
souvenirs
the
et nos
grave.
expériences dans nos tombes pour
forever.
toujours.
I have long recognized that some of my fellow Cambodians
Je reconnais
suffered
depuis longtemps que certains
during
de
the
mes
democratic
compatriotes
Cambodia
cambodgiens ont
period.
souffert pendant la période du
As
Cambodgia
I have
démocratique.
said
Comme je l'ai dit à
repeatedly,
plusieurs
I
reprises,
am remorseful for their
je
suffering
regrette
and I
ces
accept
souffrances et j'accepte
moral
la
responsibility for
responsabilité
it.
morale pour celle-ci.
I have engaged with
J'ai
this
participé
tribunal because I
à la
believe that
procédure
I
devant
have
ce
a
tribunal
responsibility
parce que
to
je
the
pense
Cambodian
que j'ai la
people
responsabilité
to
d'aider
help
le
them
peuple
learn the truth
cambodgien
about
à
what
connaître
really
la
happened
vérité à
in
propos de ce qui
democratic
s'est réellement
Cambodia,
passé pendant le Cambodgia
to explain
démocratique.
to them, as
Lui
the
expliquer,
surviving leader
en tant que
of the
dirigeant
Communist
survivant du
Party
Parti
of
communiste du
Cambodia,
Cambodgia,
the reasons
les
our
raisons
party
pour lesquelles
undertook
notre parti
certain
a
actions
entrepris
and
certaines
what the
actions
results
et quelles
were.
en ont été les
And I
conséquences.
believe that this is what most Cambodians
Et je crois
want
que c'est ce que la plupart
from
des
this
Cambodgiens
trial as
attendent
well.
également de ce procès.
However, from day one, it was my strong impression that this tribunal was not at all interested in exploring the truth. Instead, it seems to operate as though its mission was simply to endorse the instructions of a handful of officials in power and tell a tale approved by the government before the tribunal was established. And I was right. In August 2014, after 7 years of proceedings and hundreds of millions of dollars, the trial chamber issued its first trial judgment against me and sentenced me to life imprisonment in case 002/01. The judgment was a shameful failure. It didn't simply fail to deliver truth and justice. It actually managed to take us even further away from the truth and to make a mockery out of justice altogether just in order to prosecute me. My lawyers in fact tell me that an academic report was recently released which says the same thing. Despite my lawyers' efforts to encourage a more realistic understanding of events, the trial judgment was extremely oversimplifying and inaccurate. For instance, the trial chamber judges said the Communist Party of Cambodia had a strict hierarchy. They suggested that Pol Pot and I controlled every single Khmer Rouge cadre, from the lowest foot soldier to the highest members of the party's standing and central committees. They ignored evidence that the party was in fact divided internally and that some zones acted autonomously. They ignored evidence that some standing and central committee members, like Sao Phem and Rothnum, had created an opposing faction within the party that tries to overthrow the legitimate government of Democratic Cambodia in a coup organized and instructed by Vietnam. They ignored evidence that all of these events related to Vietnam's long-standing ambition to invade, expand, swallow up Cambodia, and eliminate the Khmer people and integrate Cambodia into an Indo-Chinese federation with Vietnam at the head. My lawyers' attempts to present this evidence were met with skepticism, hostility, and anger. Their microphones were cut off. The judges demonstrated extreme bias against me in the courtroom, and in their judgment, ignoring key submissions and evidence put forward by my lawyers. Hiding from the truth as the trial chamber judges did in their judgment serves no one but the Vietnamese. It does nothing to deliver justice and improve understanding. It simply threatens to reduce this whole tribunal to one useless waste of time and effort. As disappointing as the trial judges and investigating judges had been, my lawyers and I still thought that there could be a chance, however small, that things might be different before you, Supreme Court chamber judges. Accordingly, in consultation with me in December last year, my lawyers submitted to you 270-page brief in English. It reflected that very poor quality of the trial judgment by appealing it on no less than 223 grounds. Some of those grounds relate to gross violations of my right to a fair trial by both the trial and investigating judges. I want to take this opportunity to highlight the most serious violations of them all, the trial chamber's refusal
à savoir le refus de la chambre
to
de première
call
instance
Heng Samrin
de citer
as
Heng
my
Samrin
witness.
à comparaître
Heng
en
Samrin
qualité de
was
témoin.
by far the
Heng
most
Samrin était
important
de
witness
loin
for
le
the
témoin le
first
plus
trial.
important du premier procès.
My lawyers
Mes avocats
requested
ont
him
sollicité sa
as a witness
comparution
many
en tant que
times
témoin à de
throughout
nombreuses
the
reprises au cours
trial.
du procès.
As a regiment commander
En
and
tant que
deputy
commandant d'un
commander
régiment
of one
et
of the
commandant
divisions
adjoint de l'une des
which
divisions
led the evacuation of
qui a
Phnom Penh,
supervisé l'évacuation de
he
Phnom
is the
Penh,
most important person still
il est la
alive
personne
to
la
have
plus importante
participated
encore
in
vivante
the
à avoir
evacuation.
participé à l'évacuation.
Since he was one of Sao Phim's
Parce qu'il était
right-hand
l'un
men
des
in
bras
East
droits de
Zone
Sao Kim dans le
military,
commandement militaire de
he
la
could
zone
have
Est, il
testified
aurait pu témoigner
extensively about how the
abondamment
evacuation was to be carried out.
de la manière dont
I
l'évacuation a
am
été mise en
sure he would
œuvre.
have agreed with me that
Je suis sûr qu'il
no
aurait
unnecessary
confirmé
harm
le
was to
fait
be
qu'aucune
inflicted
violence
upon the
inutile ne
people of
devait
Phnom
être
Penh
infligée à l'encontre des
and
habitants de Phnom
other
Penh et
cities.
des autres villes.
He could have confirmed my position
Il aurait
that
pu
there were
confirmer ma
never any
position,
orders to
qui
kill
consiste à dire qu'il n'y a jamais eu d'ordre
Lon
visant
Nol
à tuer
soldiers
les
and
anciens soldats de
officials
Lon Nol
or to
ou
kill innocent
les
people during
fonctionnaires de
the
Lon Nol
evacuation.
ou encore des innocents pendant
He
l'évacuation.
could also have testified
Il
about
aurait
his
également
plans
pu
to overthrow
témoigner
the
au
government
sujet
of
de ses plans pour renverser
Democratic
le gouvernement du
Cambodia
Kampuchea
in a coup by
démocratique par un
Vietnam
coup d'État fomenté par le Vietnam.
because he was a senior member of that faction
Parce que
and
précisément,
attended secret
il était un
meetings
haut
in
responsable
Private
de cette
Town
faction
led
et
by
parce qu'il
Sao
a
Phim
participé
to
à des
plan the
réunions
coup.
secrètes dans la ville de Prevang,
Indeed,
dirigées par Sao Phim pour préparer ce coup.
when Vietnam cruelly invaded Cambodia, Heng
Effectivement,
Samrin was the
quand le Vietnam
person
a
they
cruellement envahi
installed
le
as the
Cambodge,
new leader
Heng
of
Samrin
their
fut la
puppet
personne qu'ils ont
government.
installée au poste de dirigeant de
But
leur
not
gouvernement
only was
fantoche.
Heng Samrin my most important witness,
Non
Heng
seulement
Samrin
Heng
was also
Samrin était
my
mon témoin
only
le plus
character
important, mais Heng Samrin
witness.
était aussi mon seul témoin de personnalité.
I have known Heng Samrin well for over 60 years.
J'ai
He
bien
knows
connu
me
Heng
very
Samrin pendant
well.
plus de
He
60 ans. Il
used
me
to be
connaît très
my
bien.
messenger
Il était mon
and he came
messager.
with me to
Et il
meetings with
m'accompagnait
Sao
à des
Phim.
réunions avec Sao Phim.
Sao Phim was like a
Sao Phim
relative
était
to
comme un
me.
parent pour moi.
I was very close to
Et
Sao
j'étais très
Phim.
proche de lui.
His defection to Vietnam
Sa
was
défection au profit du
devastating to
Vietnam
me.
m'a dévasté.
Heng Samrin could have testified in
Heng Samrin
detail
aurait pu
about many
témoigner en
things
détail
that
au
happened
sujet de
in
beaucoup de
Democratic
choses qui se sont
Cambodia
passées pendant le
and
Kampuchea
about my
démocratique,
character.
ainsi que de ma
My
personnalité.
lawyers told me that
Mes avocats m'ont
they
dit
don't know of any court in
qu'ils
the
ne connaissent
world
aucune
that
cour
would
au
ever
monde
refuse
qui ait un
to
jour
hear a
refusé
character
d'entendre
witness.
un témoin de personnalité.
Despite all of these reasons, every
En
single
dépit de toutes
Cambodian
ces
judge
raisons, tous les
in
juges
the trial
cambodgiens de la
chamber
chambre de première
refused
instance,
to call
sans
Heng Samrin
exception,
as a
ont
witness,
refusé de citer Heng Samrin à
just like all
comparaître
the
en tant que
Cambodian
témoin,
judges and
tout comme les juges cambodgiens
prosecutors
et les
before them.
procureurs l'avaient fait
They
avant
said
eux.
that trying to summon Heng
Ils ont dit que
Samrin,
tenter de citer
who
Heng
is the
Samrin, qui est
president of
actuellement
the National
président
Assembly,
de l'Assemblée
could lead to
nationale,
many
aurait
problems,
engendré de
and
nombreux
they
problèmes
weren't prepared
et qui
to
n'étaient pas
take
prêts
this
à prendre ce
risk.
risque.
They admitted that
Ils ont
these
admis que ces
problems
problèmes
would undermine
ont
the trial
influencé la
chamber's
position de la
position.
chambre de première instance.
In doing so, the national judges
En
admitted
agissant de la
that this
sorte, les juges
tribunal
nationaux
is
ont admis
powerless.
que ce tribunal est impuissant.
It is disrespected
Il
and
n'est pas
it is simply
respecté
acting
et il
under the
agit seulement
pressure
sous la
of
pression du
the
gouvernement.
government. And international judges
Les juges
are no
internationaux
better,
ne sont pas mieux.
for although they agreed that Heng Samrin
Bien qu'ils
should
aient
have
admis
been
qu'Heng Samrin aurait
called,
dû être cité à comparaître,
they
ils
refused
ont
to
néanmoins
consider what the
refusé
effect of his evidence would have been
d'évaluer les
on
conséquences
their
que ce témoignage
judgment.
aurait pu avoir sur leur jugement.
Why are the
Alors pourquoi
international
donc les juges
judges even
internationaux sont-ils
here then?
ici?
Because of the decision not to
À
call
cause
Heng
de cette
Samrin
décision
and because of the
de ne pas
poor
citer Heng
quality of the
Samrin à
judgment,
comparaître et à cause de la
I
qualité
discussed
médiocre du
with my
jugement,
lawyers
j'ai
to seek
décidé en
the
concertation avec mes
disqualification of the trial
de
chamber
solliciter la récusation
from the second trial
de la
against
chambre de
me.
première instance pour le deuxième procès à mon nom.
My lawyers argued that it was clear
Les avocats ont soutenu qu'il était clair
that
que
the
les
judges were
juges
biased
étaient partiaux
and could not bring an open
et
mind
étaient
to the
incapables
second trial
d'aborder le
against
second
me.
procès à mon encontre avec un
Of
esprit
course,
ouvert.
this motion was dismissed,
Évidemment,
although
cette requête
one
a été
international
rejetée.
judge said
Bien
he
que
would
l'un
have
des
agreed
juges
with us
internationaux
we were
dit
forced
qu'il aurait été
to
d'accord avec
press
nous.
ahead in the second trial with
Nous
the
avons
same
néanmoins été
judges
contraints d'aller de l'avant
and
dans
the
ce second
same
procès avec les
unfair
mêmes
procedures
juges et
in
les mêmes
place.
procédures injustes.
It has now been nearly a
Cela fait
year
bientôt
since
un an
we started hearings in
que
the second
les
trial,
audiences ont commencé dans
and
le
it
cadre
has
de ce second
proved to
procès.
be at least as frustrating,
Et
biased,
ce procès
and
s'est avéré
unfair
être
as
à
the
tout le
first
moins aussi
trial.
frustrant, partial et
Maybe even
inéquitable
more
que le
so.
premier, peut-être plus encore.
The situation has in fact become so
La
bad
situation est
that
en
3
réalité
months
devenue
ago,
si mauvaise
my
qu'il y a
lawyers
3 mois, mes
walked out
avocats ont
of
dû quitter le
proceedings in
prétoire
response
en
to
réaction
the latest
à la toute
injustice.
dernière injustice commise.
As I explained, my lawyers
Comme je
could
l'ai
no
expliqué,
longer take what
mes
was
avocats ne pouvaient
happening
plus
in this
endurer
courtroom.
ce qui se déroulait dans le prétoire.
The injustice that
L'injustice de
day
ce jour-là
was one of
était
many,
une injustice parmi tant d'autres,
and too much for them to bear,
et ce fut trop à supporter pour mes avocats.
especially knowing that there would be more and more
D'autant qu'ils
injustices coming
savaient qu'il y
in the
aurait
future.
encore plus
And while my lawyers have
d'injustice
done their
dans le
best to
dans le
press
futur.
on and
Et
continue
alors que
with the
mes avocats ont
trial,
fait de leur mieux pour
every
aller de
day
l'avant
they
et
face
continuer ce
more
procès jour après jour,
injustices.
ils ont fait face à de
At the same
nouvelles
time as
injustices.
participating in
Parallèlement à
the
leur
second trial,
participation au
my
second
lawyers
procès,
have also
mes
been very
avocats
active
ont
with
été
the
très actifs
Supreme Court
devant
chamber.
la chambre de la Cour suprême.
In consultation with me, they have
En
filed
consultation
many
avec moi,
requests
ils ont
to
soumis
admit
de
new
nombreuses
evidence when
requêtes afin
this new
que soient
evidence
admis
has come to
de
light.
nouveaux éléments en preuve. Quand ces éléments,
This new
ces
evidence,
nouveaux
more than
éléments ont
ever
été mis au
before,
jour. Ces nouveaux
provides
éléments de preuve,
insight
plus encore
into the head
qu'auparavant,
and
donnent
tail
un
of the
aperçu de
crocodile, and not
des
just the
tenants et
crocodile's
aboutissants, de la
body.
tête et de la queue du
The
crocodile, et non
evidence
seulement du
confirms
corps du
that
crocodile.
Vietnam
Ces éléments
attempted
de
a coup
preuve
d'État
confirment que
during
le
the
Vietnam a tenté
democratic
de perpétrer un coup d'État
Kampuchea
pendant la
period.
période du Kampuchea démocratique.
According to the filmmakers Ted
D'après
Sambat
les
and Robert
réalisateurs
Lampkin,
Ted Sambat
already in
Robert
May
Lampkin,
1975, Sarpam
déjà
and
au mois de mai
Ruthnium
1975,
held a
Sarprim et
meeting in
Ruthnium
Phnom
ont organisé
Penh.
une réunion à Phnom Penh.
With some other zone leaders,
Avec
they
certains
agreed
autres
to
dirigeants
try
de
to
zone, ils se sont
destabilize
entendus pour
and overthrow the
déstabiliser et
government
renverser le
of
gouvernement du
democratic
Kampuchea démocratique.
Kampuchea. Their plans included
Leur
assassination
plan comprenait des
attempts
tentatives
against Pol Pot,
d'assassinat à l'encontre de Pol Pot,
stocks of
des stocks
weapons,
d'armes,
uniforms,
d'uniformes,
food,
de
and
nourriture
other supplies
et autres
were
produits ont été
gathered.
rassemblés.
Meetings were
Des
held.
réunions se sont tenues.
False propaganda was
Une
spread.
fausse propagande a
Many
été
people
disséminée.
were starving because of their
De nombreuses
plans.
personnes ont été affamées à cause de leurs plans.
Two coup attempts took place in
Deux tentatives de
1976,
coup d'État ont eu lieu en 1976,
namely an explosion in Siem Reap in
savoir une
February
explosion à Siem
and
Reap
an
au mois de
attack
février et une
outside
attaque à
the
l'extérieur
Royal
du Palais
Palace
Royal
in April.
au mois d'avril.
According to the evidence, these
D'après les éléments
plans
de
were
preuve,
part of a much
ces plans
grander
faisaient partie
scheme
d'un
of
projet
Vietnam,
bien plus
which
vaste du
began
Vietnam,
in 1977 and
qui a
involved
commencé en
several
1977
zones
et qui
around the
impliquait de
country,
nombreuses zones
which
dans le
would
pays,
crush our government
mais qu'elle
militarily.
devait anéantir militairement notre
The new
gouvernement.
evidence now clearly
Ces
tells
nouveaux
us
éléments de
that
preuve montrent
if
désormais
this
clairement
rebellion would not succeed, Vietnam would
d'échec de
invade
cette
Cambodia
rébellion,
directly.
et il était prévu que le Vietnam
And as we
envahisse
all
directement
know,
le Cambodge.
That is what
Et comme
they
nous le savons
finally
tous,
did,
ça est précisément ce qu'ils ont
using
finalement
over
fait,
100,000
en
soldiers
utilisant une centaine de
and
milliers
some
de soldats et
tanks.
quelques chars.
In the beginning, my lawyers and I were encouraged
mes avocats
by
et moi-même
the
avons été
Supreme Court
encouragés
Chamber's
par les
response
réponses de la
to
Chambre de la
the
Cour
evidence
suprême
request.
à nos requêtes en admission
It
de nouveaux
seemed
éléments à
as
titre de
if
preuve.
it was the first time at this tribunal
On aurait dit
that
que c'était la
judges,
première fois
including
devant ce
Cambodian
tribunal que des
judges,
juges, y compris
were
des juges
willing to
cambodgiens,
come to
étaient
discuss with
véritablement
an
disposés à traiter
open
ce dossier
mind,
avec un esprit ouvert,
to engage in
à
a real
engager
discussion
un
about
réel
the
débat
issues.
à propos des
My
vrais
lawyers
problèmes.
were particularly encouraged by the Chamber's agreement
Mes avocats étaient
to open
particulièrement
an
encouragés par
investigation
l'accord de la
into
Chambre
evidence
concernant l'ouverture
that
d'une
was
enquête
collected
à
by the
propos des
filmmakers
preuves collectées
Ted
par les
Sambat
réalisateurs
and
Ted
Rob
Sambat et
Lemkin.
Rob Lemkin.
They were also further encouraged
Ils ont
when
été
the
encore plus
Chamber
encouragés
scheduled
lorsque la Chambre
testimony
a prévu
of 3
d'entendre les
witnesses
témoignages de 3
we
témoins
had asked
que nous
to
avions
testify
sollicités en appel.
on appeal. In light of all of these developments, my lawyers had been preparing for and carefully and patiently awaiting these appeal hearings. Their disappointment was immense, therefore, when the chamber announced that not one of the witnesses we requested would be called to testify on appeal. None. Not Heng Samrin, not Rob Lemkin, not Tate Sambat. My lawyers had thought that the chamber would at least call Heng Samrin, that what he has to say is obviously incredibly important, but they were wrong. In the end, you decided in the same way as all the judges before you. How disappointing. That Supreme Court chamber decision also dismissed all our new evidence and offered no reasons at all, making it impossible to understand. Your Honors, because of your decision, the outcome of the appeal is now irrelevant to me. It has become clear to me that the Supreme Court chamber is just as biased, unwilling, and as afraid as those that have come before you to really explore what the truth worth. You refuse to give me even just the chance to tell the Cambodian people my side of the story. Your decision has confirmed that my assessment of this tribunal has always been right, as the court would serve only those who it belongs to. It is nothing but a meaningless effort designed just to convict me. Accordingly, following a discussion with me, my international lawyer, Victor Copper, is not participating in these hearings. I will also leave these proceedings once I have finished making my comments, and I would also like to instruct my national lawyer, Mr. Son Arun, not to participate in these proceedings any further and not to respond to any kind of questions by the judges or their other parties. We choose instead to rest on the arguments made in my appeal brief. However, I have stopped short of withdrawing my appeal altogether in honor of the responsibility I continue to feel to have the Cambodian understand the truth of what really happened in the democratic Cambodia period. I urge you, judges, to have courage, to consider your commitment to truth and justice when writing your judgment. The Cambodian nation,
la nation cambodgienne,
which has clear and delight knowledge, is waiting for you to deliver truth and justice in your judgment. Cambodia will never have this opportunity again. Thank you.
Merci.
ចឹងតាមសេចក្តីថ្លែងការណ៍
President,
Le Président,
after hearing the statement of the
après
accused,
avoir entendu la déclaration de
you
l'accusé,
not intended to be here in the courtroom. Is that correct?
avez-vous donc l'intention de vous retirer du prétoire?
And another matter is about the co-counsel, the National Co-Counsel for Mr. Nguyen Chie. Are you willing to participate in the courtroom?
Êtes-vous prêt à Restez au prétoire.
Mr. President,
Monsieur le Président,
stated in the statement of the accused,
comme l'a indiqué
my
l'accusé dans sa
client
déclaration,
instructs me not to participate in the
mon client m'a
appeal
demandé
hearing
de ne
today.
pas participer à l'audience en appel aujourd'hui.
President, so
Le
it
Président,
means that you will
Cela
not be
signifie donc que
participating
vous
in
ne
the
participerez
appeal hearing.
pas
But from what
à
I
ces
heard
audiences.
from the accused, he stated that you will be
D'après
here
ce qu'a
but
dit l'accusé,
not
il
respond
semblait avoir dit
to
que
any
vous resterez
question or any
présent sans
comments.
répondre à des questions ni formuler des commentaires.
Sonaron.
Maître
In
Sonaron,
the statement of Mr. Nguyen Chia,
dans la déclaration
he instructed me
de
to
M. Nunchia,
leave the courtroom
il m'a donné l'instruction de quitter le prétoire
after the break.
après la pause.
He instructs Sonaron, the defense counsel, not to respond any question or comments, and also not to participate
à
in
son
the appeal
avocat
hearing
Sonaron
after
de
the
ne
break.
pas répondre à des questions,
I think
de
it
ne
is
pas formuler
clear
des commentaires et de ne
enough
pas
from the
assister aux
statement
audiences
of the
après la pause.
accused.
Je pense que la déclaration de l'accusé est claire.
Counsel, this chamber's considered opinion that it is not for the accused to decide whether you stay or not in the courtroom. It is only the chamber that can dismiss you upon such an application. Meanwhile,
une fois que vous en aurez formulé la demande.
it is obligatory that the
En
accused
attendant,
have a counsel, and as such, the counsel needs to stay in the courtroom. As to the presence of the accused, we may discuss whether we consider it obligatory or not.
Nous pouvons délibérer de la présence obligatoire.
You
ou
may
non
want
de
to consult
l'accusé.
Internal Rule
Je
22.4,
vous renvoie au règlement intérieur
Article
22.4,
301 of the Cambodian Code of Criminal Procedure, and Article 7 of the administrative regulation of the DSS that are binding upon you.
Règlement administratif du DSS. Tous
Thank you.
sont contraignants.
I think it will serve this appellate hearing if the parties kindly
Je pense
follow
qu'il est dans
the
l'intérêt
order of the
de
proceedings
l'appel
as announced by
que
Mr.
les
President,
parties suivent
which
l'ordre
commences with the report
et le calendrier de
of the
la procédure
rapporteurs
tel qu'il a été présenté
on
par
the
le
part
président, à
that we will
savoir,
be discussing today,
commencer par le rapport des co-rapporteurs
following which
sur
the
le
parties are
sujet qui
invited
nous
to
concerne
furnish any
aujourd'hui.
comments they may
Après
wish
ce
to
rapport,
make.
les parties pourront s'exprimer.
President,
Le président,
I would like to clarify the matter with you, counsel. A while ago,
donc,
the
maître, je
accused
souhaiterais que l'on
stated
clarifie cette
that he will
question.
not
Tout à l'heure,
be
l'accusé a
present
indiqué
in the courtroom,
qu'il n'assistera
and as
plus
clearly
aux
stated
audiences.
by Judge Millard,
Comme vient de nous le dire la
the
juge Millard,
counsel is required to be in the courtroom in accordance
l'avocat de
with Article
l'accusé doit
301
rester au
of the
prétoire
Cambodian
conformément à
Criminal Code
l'article
of
301
Procedure.
du Code de procédure
I understand
pénale
that
du
there is
Cambodge.
an instruction from your
J'ai bien compris
client,
que votre
but
client,
you are obliged
vous a
to
donné,
be here in the courtroom in
l'instruction de
accordance
ne
with
pas y
Article
rester,
301
mais
of
conformément à
Cambodian
l'article 301
Criminal
du Code de procédure pénale,
Procedural Code. So
vous
now
êtes
I want to
obligé
make
d'y
it clear
rester.
with you.
Donc,
You will be here in the courtroom
vous allez
or
bien
you will
rester au
leave
prétoire ou
the
vous avez
courtroom as
l'intention
well.
de quitter le prétoire, maître?
Sonaron, thank
Maître
you,
Sonaron.
Mr. President.
Merci,
I would
Monsieur
like
le
to
Président.
inform Your Honors that we are professional. I am
Je
a professional lawyer.
Signale au
I
juge que je
must
suis un avocat
respect all
et un
existing
professionnel
laws,
et je me
and
dois
let
de
me make it
respecter
clear
la
that
loi.
I duly respect this chamber. However, I am required
réaffirme
to
mon respect
listen
pour
to
la
the
Chambre.
instruction of my
Cependant, je me
client.
dois de suivre les instructions de
not,
mon client,
My client will dismiss me.
sans quoi
mon
Therefore, I
ne fera plus
shall
appel à
and
mes
must
services.
listen to the instruction
Je
of
me
my
dois
client.
donc d'écouter et de suivre les instructions de mon client.
Thank you.
លោកប្រធានខ្ញុំសូម
Kong Som-on,
Maître
Mr.
Kong
President,
Som-on, Monsieur
allow
le
me to
Président.
make a comment here.
Puis-je prendre la parole?
តាក់ទងបញ្ហា
President,
Le Président,
please all be seated.
veuillez vous asseoir.
This means that you will recuse.
Vous souhaitez donc vous recuser.
You will accuse and you will leave the courtroom. So it
L'interprète
is
se reprend. Vous souhaitez donc
a
suivre les
matter
instructions de
for you to
l'accusé
decide.
et
As
quitter
Judge
le
Milad
prétoire.
and I
Donc,
informed you
vous estimez que
already,
c'est à vous
you
d'en
are
décider, mais comme
obliged
nous venons de
to
vous le dire,
present
vous êtes obligé
in the courtroom in a felony
d'être
case. So
présent
it is
au
a matter
prétoire
of the decision
lors
by the
d'une
Supreme
audience
Court chamber in
pénale.
this case.
Et donc,
So now, once
ici,
again, I will give you
devant la Chambre de la
another
Cour suprême,
chance
vous êtes obligé de rester
to
présent. Je vous
clarify the
donne
matter.
encore l'occasion
Sonaron.
de préciser vos intentions.
In
Maître
accordance
Sonaron.
with Article 28 of the statute,
En application de l'article
we
28,
will rely on our conscience and we will also need to listen to the instruction of clients
nos
for the
convictions
interests
et
of
les
the
instructions
client.
du client dans l'intérêt de mon client. On behalf of the chamber, I am warning you that if you leave the courtroom, you will be in contempt of court, and we will be drawing consequences of it. This chamber does not allow you to leave. I also want to inform you that this is crystal clear for this chamber, that this appears like a tactics aimed at obstructing the proceedings. It's been used in other international tribunals unsuccessfully, and we have citations from cases where international criminal tribunals did not allow such a walkout, even upon instruction from the client. This is our final position on this matter. I suggest the hearing continues. Je propose de poursuivre l'audience.
Sonaron.
Maître Sonaron.
Judge Milad, I heard
Madame la juge,
you mentioned about the instruction of the chamber. But I must comply with the statute of the Bar Association of the Kingdom of Cambodia, Article 58. Lawyers will have to rely on our conscience and will have to comply with the instruction of one's client. So I will need time to consult with my clients because I am representing my clients. I understand, I respect the chamber, however, I have to listen and respect my client as well. And it is very clear from the statute of the Bar Association of the Kingdom of Cambodia.
De l'association de l'ordre du barreau du royaume du Cambodge
Lawyers
est très clair à cet égard.
Needs to receive agreement of the client
Les avocats
whom the lawyer
doivent
is
avoir
representing.
l'accord.
So I humbly request your honors to consider the statutes of the Bar Association of the Kingdom of Cambodia. And it is my obligation to comply with that statute as well. Thank you, your honors.
Merci.
President,
you have the floor now, International Co-Prosecutor.
Your Honor, we would like to be heard on the issue of Nunchia attending these proceedings. These proceedings, as everyone knows, are extremely serious, dealing with some of the most serious crimes imaginable. He's here not because of an invitation to something like a cocktail party that you can decline to attend. He's here because he's facing extremely serious charges that involve suffering and victims from around Cambodia. It's also not his role in these proceedings to decide how they will be run. That, of course, is up to your honors. Counsel also cannot take instructions to do things that are against the rules of the court. Under the way counsel is interpreting his Bar Association rules, a lawyer would have to follow the instructions of his client to insult witnesses or judges to disclose confidential information that could endanger witnesses because it's its client's instructions. That, of course, is not the law anyway. Counsel are here to vigorously defend their clients as they've done throughout the trial and the appeal, but they're not here to obstruct the proceedings. We urge you to require Nuon Chea to be here for the majority of these proceedings, absent a medical reason for him not to be present. And thank you for listening to our
qu'il ne le soit pas. Je vous remercie.
President, you have the floor now.
Le président, Maître Salmon,
thank you very much.
Vous avez la parole.
Mr. President, good morning, Your Honors, everyone in and around the courtroom. Let me voice my intervention on
Permettez-moi
the
d'intervenir
matters
sur
which have
ces
just arisen
questions
out
qui
of
viennent d'être
this
soulevées.
in the course of proceeding. I have listened attentively to Judge Millard, and from understanding, it is a threat to the profession of a lawyer.
Ce que j'entends,
Mr. Sonaron made it clear already in his position that he receives an instruction from his client to walk out or leave the courtroom, and he is also instructed not to respond to any question or comments before the chamber. So it is clear and sufficient that the lawyer can make a decision to walk out and leave the courtroom. And if the court considers that the walkout is a contempt of the court, I believe it is a threatened by the chamber here. Lawyers enjoy freedom of profession.
Au métier d'avocat. Les avocats doivent être libres d'exercer leur métier.
Mr. President mentioned Article 301 of the Cambodian Criminal Procedural Code. I understand that we need to comply with that article. However, it is not an absolute article that we lawyers need to comply with. And the chamber can't find another lawyer to represent a client if it thinks fit. So we have to consider every point here. So the defense counsel here are selected and selected by the clients. They are not appointed by the chamber and specifically the Supreme Court chamber. And I understand that the lawyers appointed by the courts sometimes have to respect with the instruction of the courtroom, but here it is a different case. We are representing the client. We need to follow the instruction of the client. This matter arose before the trial chamber a few months ago, so it's the same case here. Thank you very much.
Dans ce même dossier, il y a quelques mois. Je vous remercie.
សូមអញ្ជើញសូមអញ្ជើញ
You have the floor now, international lead co-lawyer.
Le président, co-avocat principal, vous avez la parole.
លោកជនជាប់ចប់នឹងផ្ដល់ឱកាសឲ្យទៅដល់សហមេធាវីនាំមុខដើម្បីធ្វើសេចក្តីថ្លែង
I will first give the floor to international lead co-lawyer.
Je donne d'abord la parole au co-avocat principal international.
Merci Monsieur le Président et bonjour à tous. Nous avons juste une courte observation liée à la présence de Nguyen Chia dans cette salle d'audience. Nguyen Chia a été convoqué et nous avons expliqué à plusieurs reprises à quel point la présence physique de l'accusé dans la salle d'audience est importante. La règle 81 du règlement intérieur intime à l'accusé d'être présent. Donc de deux choses l'une, soit Nguyen Chia dépose une dispense pour raison médicale et il peut dès lors quitter cette salle d'audience, soit il ne dépose pas comme il le fait habituellement devant la chambre de première instance une dispense pour des motifs médicaux précis et dès lors sa présence dans la salle d'audience est requise et obligatoire au regard des règles et du règlement intérieur de ce tribunal.
President, you have the floor now, Mr. Accused.
Le président, l'accusé, vous avez la parole.
Counsel Sunarun, Mr. President, my client is unwell and he requests to take a rest.
Mon client est souffrant
He signaled to the bench to
pause.
seek your permission to rest as he can no longer sit
Il
in
vous a
the
fait signe pour
courtroom
vous
due to his
demander
poor health.
l'autorisation d'aller se reposer. Il ne peut plus rester au prétoire en raison de son état de santé.
President,
Le président,
the bench has discussed the problem before us. The internal rules and the Cambodian law specifies the absolute presence of the accused during the hearing, except in the case of poor health, for instance.
sauf en cas de mauvaise
If
santé,
there
par
is
exemple.
a medical report informing the chamber that he can no longer be present in the courtroom due to health condition, then he may be granted to follow the proceedings from the holding cell downstairs.
Il pourra avoir l'autorisation de suivre la procédure depuis sa
And
cellule de
indeed, we
détention
do have
provisoire.
a copy of the medical report dated 17
Nous
November
avons un rapport
2015,
médical en date du
which
17
specifies that he has
novembre
severe backache
2015,
and that he can not sit in
confirmant
a
que Nguyen
courtroom.
Chia souffre de maux de dos et ne peut pas rester assis au prétoire.
And based on this medical report, the accused is granted
Suivant
to
donc
follow the
ce rapport
proceedings from
médical, l'accusé est
the
autorisé
holding cell
à suivre la
downstairs.
procédure depuis la cellule
And
de
security
détention provisoire
personnel
au
just started
sous-sol.
to take
Garde de
the
sécurité,
accused Nguyen
veuillez
Chia to the room
raccompagner
downstairs,
l'accusé Nguyen Chia
and the AV unit
dans
is
sa cellule de
instructed to link the
détention
proceedings to the
provisoire.
room downstairs so
La
that the
régie,
accused can
veuillez
follow it.
vérifier que l'accusé est en mesure de suivre la procédure par des moyens audiovisuels.
បាទសូម
And I noticed the national co-prosecutor on her feet. You may proceed.
Le co-procureur national, vous avez la parole.
Chia Liang, good morning,
Maître
Mr.
Chia
President,
Liang,
Your
bonjour,
Honors,
Monsieur le
and good
Président,
morning,
Mesdames et
everyone
Messieurs
in
les
and
juges,
around the
bonjour à
courtroom.
tous.
It is my understanding that before the chamber is granted to follow the proceedings from the room downstairs, I have two questions that I would like to put to the chamber. However, the chamber has already made its decision to allow him to follow the proceedings from the room downstairs. I'd like to clarify on the waiver of his right to participate in the hearing. And second, in relation to his appeal hearing, he already made his statement, but I want to know for certain whether he still maintains his appeal against the judgment. And of course, the international lead co-lawyer for civil parties rightly said so that it is important to have the presence of the accused during the hearing against him. And I urge that the chamber has to make clear on this issue, although you decide already to have the accused follow the proceedings remotely. I'd like to give the floor to Judge Miller.
This chamber's opinion, the accused stated very clearly that he stopped short of withdrawing the appeal, meaning he did not withdraw an appeal, although certain representations had the effect of declaring his passive attitude during the appellate proceedings. Meanwhile, as you noticed, we already ruled that he can go follow the proceedings from downstairs upon the medical report, which we have no grounds to question. Now I am told by the President that we should move on.
President, allow me to add to this matter. Regarding the National Council for the Defense, the bench deliberated the issue, and in our view, that the National Defense Council needs to follow the instructions of his client, and it is expressly clear that he is banned or prohibited per instructions of his client to respond or to make any statement during this appeal hearing. Despite all that, the National Defense Council must be present in the courtroom during the appeal hearing, and it is your right whether you wish to respond or to make any statement or otherwise.
Vous avez le droit de choisir de répondre ou non et de faire des déclarations ou non pendant la procédure.
President, the National Defense Council, you may be seated.
Le président, l'avocat national, veuillez vous asseoir.
Do you wish to make any other points, Defense Council?
Est-ce que vous avez autre chose à dire?
In fact, the chamber has ruled that you must be present in the courtroom, and whether you wish to exercise your rights to respond to any issues raised during the appeal proceeding, or you wish to respect the instructions of your client. However, your presence is required in the courtroom. And I'd like to invite the co-rapporteurs to read the report for the sessions on the ground of appeals relating to fairness of proceedings and constitutionality of the internal rules.
Et la constitutionnalité du règlement intérieur.
Judge Momonicharia, thank you, Mr. President. And on behalf of the co-rapporteurs, myself and Judge Nihal Singhe, I'd like to read the co-rapporteurs' report in relation to the grounds of appeals relating to fairness of proceedings and constitutionality of the internal rules. Nuon Chea and Khieu Samphan submit that in the course of the proceedings before the trial chamber, there were various violations of their rights to a fair trial. Their arguments fall into 4 broad categories. First, they submit that their rights to an independent tribunal was violated. They submit that the trial chamber was deeply biased against them and incapable of impartially assessing the evidence. The lack of independence and impartiality was, in their submission, evidenced by the fact that the trial chamber did not call certain witnesses. The defense for Nuon Chea had requested to appear, notably Heng Samrin. Reference is also made to statements of Judge Cartwright, who was one of the judges of the trial chamber at a conference which, in the submissions of the defense, disclosed bias as well as alleged general shortcomings of the Cambodian judiciary. Second, Nuon Chea and Khieu Samphan raised a number of arguments alleging that their rights to an effective defense has been violated. In that regard, they submit, inter alia, that the trial chamber did not give sufficient time to the defense, did not give an opportunity to fully question certain witnesses, and failed to call key defense witnesses, notably Heng Samrin, Uk Bun Chun, and Robert Lamken. The appellants also challenged the procedure regarding the admission of documentary evidence and certain procedural orders of the trial chamber. Third, Nuon Chea and Khieu Samphan argued that the trial chamber failed to provide proper and comprehensive reasons for key decisions taken in the course of the proceedings. It is also argued that the trial chamber itself is insufficiently reasoned as it failed to address key defense arguments raised before the trial chamber. Fourth, Nuon Chea and Khieu Samphan raised several arguments that relate to their rights to be informed of the charges against them. Some of these arguments also challenge the scope of the trial in case 002/01, as the appellants argue that 1. Throughout the proceedings, it was not clear which charges were actually encompassed by the trial, and 2. The trial chamber relied on facts that were actually outside the scope of the trial, and the trial chamber erred when relying on those facts. In addition, Nuon Chea submits that the ECCC's internal rules are unconstitutional and illegal. He submits that under the applicable law, the judges of the ECCC did not have the power to adopt internal rules, and that this amounted to a breach of the Cambodian constitution. He underlines further that in accordance with the ECCC agreement, there can only be recourse to procedural rules established at the international level if there is a lacuna in Cambodian law. In other words, if there is an uncertainty about the interpretation of the applicable law or a question about its compatibility with international standards, He notes that many of the internal rules provide for fewer rights for the defense than the Cambodian Code of Criminal Procedure. This is a summary of the co-rapporteur's report. Thank you. President, thank you. And in accordance with the timetable, it will be now the time given to the parties, and first I would like to give the floor to the defense for Nuon Chea. My name is Sonarun. I am a defense counsel for Nuon Chea. My oral submission today has already been included in the statement read out by my client. For that reason, I do not have any further to add or to respond to any question by other parties. President, please be reminded that this appeal hearing is the last chance for you to make your oral response to in relation to your appeal against the judgment in case 00201, and you just confirmed that your statement or your response or oral submission is already encompassed in your client's statement. But be clear that this first session is in relation to your appeal on the issues of the constitutionality of the internal rules. And if you decide not to make any oral submission, the court still proceeds with its own timetable. And based on your confirmation, you may be seated. And we will take a 20-minute break from now. And when we return, the floor will be given to another party.